Good afternoon, everyone, and welcome to the Centre for Environmental Justice webinar on the Planning and Development Act. I'm delighted to see such a broad range of individuals and organisations in attendance today, including community and environmental groups, residents' associations, legal experts, and public bodies. We hope this webinar will provide an overview of some of the key concerns we have in relation to the Act, and we hope to answer any questions you may have about it. For those of you who may not be aware of us or the work that we do, Community Law Mediation is an independent law centre and charity working since 1975 with underserved communities through the provision of free legal, education and mediation services. And we also engage in policy and law reform. In 2021, we opened Ireland's first ever Centre for Environmental Justice, which works to ensure that no person or community is disproportionately impacted by climate change or other environmental harms, and that environmental measures and climate action protect and build equality and social justice. So we offer free legal information, advice and education on environmental justice, and we also advocate for a rights-based approach to environmental policy and law reform. And with this in mind, we've been tracking the Planning and Development Act since it was drafted in 2019 and have been raising concerns and making submissions on the access to justice provisions of the Act in particular since then. But maybe first to ask, why is planning important? Well, it shapes and impacts almost every single aspect of our daily lives, where we live, how we travel to work, the amenities and services that we have nearby. It impacts our physical and our mental health, including the air we breathe, the level of traffic and noise in our local area, our exposure to environmental hazards, our access to and connection with the natural environment, as well as our own sense of belonging within our community. And planning in particular has a crucial role to play in how we protect the environment and adapt our communities to deal with the impacts of climate change, like flooding and heat waves. Proper planning basically ensures that the right development happens in the right place and at the right time. In terms of this Act itself, it was signed into law in October 2024, and its purpose is to consolidate all of Ireland's previous planning legislation and make our planning system more streamlined and straightforward. Staggeringly, however, it runs to almost 870 pages long. Much of the debate around the legislation focused on the need to achieve a balance between robust and timely decision-making by expert planning bodies with the rights of the public to participate in decision-making processes and to challenge decisions in the courts. Perhaps tellingly, the President of Ireland, on signing the Act, issued a statement which responded to concerns raised in submissions on the constitutionality of aspects of the bill. And he concluded that the President's decision to sign this legislation leaves it open to any citizen to challenge the provisions of this bill in the future. As Community Law Mediation outlined in our submission with Environmental Justice Network Ireland, in an era of increasingly urgent climate and biodiversity crises, the importance of judicial review, in particular for environmental and climate accountability, cannot be overstated. It's a vital mechanism for ensuring that the development that is carried out aligns with our climate and environmental goals, as well as state policies and plans. And Ireland's very poor track record in meeting our climate obligations does suggest that the role of pushing to ensure achievement of our targets will fall largely on the public and on NGOs. So in this webinar, we will hear from environmental law experts about judicial review costs, who can bring cases and when, and what the implications are of this new Planning and Development Act. But before I hand over to our expert speakers, I'd like to remind everyone to please put any questions you have into the Q&A box. We will do our best to get to as many questions as we can before 1 p.m. We're delighted to be joined in this session by Tom Flynn and Adjunct Ibreen. Tom Flynn is Senior Counsel and a member of the Inner Bar of Ireland, who practices primarily in all aspects of public law, including judicial review, planning, environmental law, housing law, compulsory purchase and acquisition. He is co-editor of the Irish Planning and Environmental Law Journal and an Adjunct Associate Professor in the School of Architecture, Planning and Environmental Policy in University College Dublin. He is current chairperson of the Planning, Local Government and Environmental Bar Association of the Bar of Ireland and is also a director of the board of Fold Housing Association. So I'm going to pass over to yourself, Tom, first to kick us off. And thanks so much for joining us today.
Good afternoon, everybody. Thank you very much, Clodagh, for that introduction. Just hope everybody can hear me. Okay, I'm going to share my presentation with you now. Okay, so obviously, Clodagh's already touched on a number of issues here. What I'm going to do in this presentation is give you an overview of some aspects of the new Act. And by definition, I'm selective in what I'm covering. I'm going to cover a number of key provisions insofar as they impact on access to justice. And as Claude has already said, the 2024 Act is the most significant consolidation and reinstatement of planning law since the previous 2000 Act. So my focus is going to be on Part 9, judicial review and decision making, which are some of the provisions which engage most directly with the issue of access to justice, and specifically the procedures on standing. And I'm going to touch on some aspects of the rules governing legal costs, and ATTRACTA is then going to deal with those rules in much greater detail because they're quite complex. Just to briefly mention the status of the 2024 Act, that should be not 2004 Act, as previously mentioned by Claude, it was signed by the President in November, and a slightly quite unusual statement by the President at the time. There had been calls for it to be referred pursuant to Article 26. You'll see there that the President declined to do that, and he made a quite unusual statement that he took the view that the difficulty with an Article 26 reference is that if the constitutionality is challenged and that it's upheld, you cannot challenge the provisions further in relation to it. But those comments are interesting.
Sorry, yeah. Tom, you're not sharing your screen, your slides.
Oh, sorry.
Apologies for the interruption.
No, you're quite correct to do that. I thought they were being shared. They're being shared now, are they?
We can see them now. Thanks, Tom.
Sorry about that. Sorry, apologies. Thanks for that intervention, ATTRACTA. So we've gone through some of this already. So there is an implementation plan. I mean, to date, very few of the provisions have been commenced. There is an implementation plan published in March, and it talks about a phased introduction in blocks A to D. And some of the provisions relating to judicial review are to be commenced relatively soon in the block A methodology, and other parts at a later stage. I think ATTRACTA may go into that in more detail. Either which way, it probably certainly by this time next year, most of these provisions will be enacted. It seems to be the case. So just in terms of context, before we get into the details, the context is pretty clear. Obviously, concerns around delivering infrastructure and housing. The programme for government proposed a review and reform of judicial review. The Attorney General then engaged in a technical review of the Planning and Development Act 2000, and there was a stakeholder consultation forum. So while there was a process of consultation, I've made the point here that in contrast, for example, to a very similar fundamental review of company law, there was no company law review group or no extensive review of planning law, which underpinned this Act. And I think that is to be regretted because I would have thought that planning law is equally as important as company law in terms of the impact it has on society, and a more comprehensive process of review would have been better. So we've already mentioned, the objectives of the bill were highlighted to bring clarity and consistency and streamlining and so on and so forth. And just generally, the 2024 Act introduces significant but not radical changes, just in a very general sense, to the planning system. It's not a complete review of the planning system. Very large elements of the existing system remain in situ, but there are some very significant changes, not least in costs. And we'll go through those in relation to it. And also, I just want to make clear as well, there are some very good elements to the bill, in the sense that a lot of the language of the preceding 2000 Act and a lot of the procedures have been clarified significantly. So there's not one shouldn't, in my view, be entirely negative about the new act. There are some elements of it, but having said that, there are some elements that raise issues in the context of access to justice. Now,
apologies for the interruption. Would you mind clicking on present under the slideshow tab? Someone in the audience has just asked for that would give us a better view of your slides, if that's all right.
I'm looking for this now.
So just at the top of the screen, there is a slideshow tab, and then in there, if you click present.
Oh yeah, okay.
Yeah. From current slide.
Oh, yeah, okay. All right.
Thanks a million.
Okay, that's fine. So I just want to highlight one issue is a change in the hierarchy of the planning, which isn't directly related to judicial review, which is our main focus. But the main change that's going to occur here is the hierarchy of planning and policy under the Act is going to change. And a central role will now be played by what's known as national planning statements, which are effectively replacing the old planning guidelines and the ministerial policy directives, and will contain national policy and planning matters. So, and this is the new hierarchy, and you see right at the top is the national planning statements. And then if we go further, you'll see here in this slide where I've explained how that will work. And in essence, the national planning statements will be formulated by the minister, and they will then have to find their way into, by way of a process of material consistency and amendment of existing plans to ensure the plans are consistent with the planning statements. So the planning statements really are now arguably the central planning documents within the system, possibly usurping the development plan, which for many people would have been seen as the primary planning document. Now, there are arguments in favor of that, just to be clear, to have a consistency of approach across the country in terms of planning policy. But one clear effect of it is it concentrates powers in relation to planning very much in the ministerial hands. So there's a concentration of power moving towards the centre from arguably the individual local authorities themselves. So that's of significance in its own right in terms of ensuring accountability. And that provides a general context in which we go on to discuss judicial review. And again, just quickly, the main changes here are new procedures around commencement, new rules on standing, and new cost rules. And also just to highlight the right of appeal to the Court of Appeal is abolished. There's only the leapfrog Supreme Court appeal will now be available only. So one key change is the abolition of the requirement to obtain leave. There will no longer now be a requirement to obtain leave ex parte and go into court and go through that process. So you just commence the process by a notice of motion. There's a requirement to notify the other parties, and there's time limit remains in place. There will be other procedural requirements that must be complied with. And there's also a new provision which makes a provision for the application to strike out judicial review that's been obtained on leave. So on one level, you could say, well, this is a good development in that it removes the barrier for leave. And the rationale behind that is that most people obtained leave in any event. So, what was the point of doing it? So it may increase the speed of which proceedings are heard. I'm just not sure about how it'll operate in practice. One of the advantages possibly of the leave application is it allowed a certain filtering of grounds and also a certain filtering of some cases. And if that is removed, one could then have a situation where it might, in a sense, result in more litigation in the short term. At least the initial barrier of leave isn't there anymore. And particularly, for example, in the context of lay litigants won't have to obtain leave. And generally, while leave is obtained, in certain cases, the leave filtration could be argued to be effective in certain categories of lay litigant cases, which really didn't have any merit or wouldn't fall to be considered as stateable. Those cases will now, it appears, just go into the system anyway. So I'm not sure and there would be mixed views within the profession, including people who act for developers as well, as to whether, in fact, that's just a universally good idea. We just have to see where that goes. The next requirement is the sufficient interest requirement, which exists and remains. But there are significant changes to the sufficient interest requirement. So you won't be regarded as having a sufficient interest unless you can establish that you are maybe directly or indirectly materially affected by the matter. So that's a new requirement. It's a different requirement. It's an additional requirement. It's subject to certain caveats, which I'll discuss in a moment. It isn't statutorily defined. So the first thing to say is that the courts will have to, in the course of litigation, begin to assess that and what does it mean. And there's a degree of uncertainty inherently arising out of that. There are certain exceptions. There's an exception if the proceedings relate to a development that's likely to have significant effects on the environment site or contravene a provision or act under the environment. You should be regarded as having sufficient interest, regardless of whether or not you are directly or indirectly materially affected by the matter. And then there are certain other conditions around that, which I'm not going to read out and go through. So again, that's a kind of a carve out and a relaxation of the rule in certain circumstances. Again, it's a new provision. And again, it's a provision I think that one could foresee will generate litigation, and the courts will have to tease out and analyse exactly how this is to be applied, exactly how this is to be interpreted, and what the standards are in relation to it. Again, if you're other than an unincorporated body, okay, you'll be regarded as having a sufficient interest, regardless of whether or not may be directly or indirectly affected, where you've made a material, a submission of a material nature. Again, this is a new provision, so you've made a submission of a material nature, and what that means may have to be assessed before the relevant body, before whose decision or act you're questioning. So most likely that will be the board. And the med submissions referred to in accordance with the requirements, so that have to be valid submissions. Again, that's a new provision, and it remains to be seen exactly how that'll have to be interpreted. And again, the unincorporated body is put in a position, a slightly different position, should not be regarded as having a sufficient interest in a matter to which a ground is pleaded, subject to certain exceptions, and they are set out in the legislation in relation to it. So that's quite a technical introduction of provision. Those provisions appear to have been introduced to address concerns that were arising in relation to allegations that there were unincorporated bodies or perhaps companies being formed at very short notice to take proceedings. And it was felt that a policy view was taken that wasn't appropriate in relation to it. But these new provisions will have significant impacts on both corporated bodies and unincorporated bodies who will have to comply with these additional requirements. So they are additional requirements. Obviously, a question then arises as to whether these additional requirements comply with our House requirements and associated EU obligations, or whether they are something that would not be considered to infringe on those provisions, because there are, it's not an unlimited. The our House obligation it does allow some scope for kind of local standard requirements to be imposed. Again, that is to be anticipated that type of argumentation will come before the courts, and the courts will have to look on that. So that's one of the most significant changes for people to be aware of. Arguably more significant is the changes in relation to costs. And again, just in relation to costs, and Attract is going to deal with the granularity of this later. So the current rule, most people know, there is a special cost rule. It effectively means that there's no order for costs against an applicant, subject to certain exceptions. But obviously the possibility to recover costs if you're successful in full or part. There are the frivolous and vexatious exceptions. Now, after a long and protracted period of kind of satellite litigation, which resulted in conflicting authorities and multiple cases as to what exactly was the scope of this rule, how did it apply, to what type of cases did it apply. The Supreme Court issued a definitive decision in a case called Heather Hill, and that kind of has resulted in a situation where the law on costs is now relatively settled. So people have some certainty around that. The other point to note about the existing system is the costs are adjudicated in the normal manner. So if you take a case, you win, you get an award of costs, you go off to the adjudication process like you do in any other cases. And obviously those provisions purport to comply with the requirements of the Aarhus Convention and the EU obligations. Now, there would be people who would argue that they don't, and there would be contrary views that they do in relation to it. But obviously, these are the not prohibitively expensive requirements and the fair and equitable requirements under the Convention and associated obligations imposed under EU law. So there's a fairly significant change introduced in the new rule. Firstly, and this is where it doesn't apply to everything. It applies to Aarhus proceedings, which are defined there as an appeal taken in relation to Aarhus, basically anything associated with Aarhus proceedings, including a CJ-EU reference or interim or interlocutory applications. And that's your definition of Aarhus proceedings set out in the Act. Certain things are excluded from that. You'll see claims for damages and so on and so forth. So that's the type of proceedings that are covered, judicial review of planning decisions effectively, which contravenes a provision of the Act or made under the Act relating to the environment. Again, you can anticipate perhaps some argumentation around that. The general rule is largely the same as the preceding rule. So each party bears their own costs, and you recover costs to the extent to which you succeed. There are exceptions, and you'll see there in the exceptions, they largely mirror the previous exceptions, except there's a new provision now that the court may order costs in favour, where they take the view that the purpose of the proceedings was for the purpose of delaying or developing or securing payment of monies and gifts in arising from the manner of the conduct of the proceedings. So that provision relating to delaying or developing development is a new provision, and that follows in line of certain allegations that people were taking proceedings just so they could in effect recover costs in relation to it. So that provision is there, and it gives the court the opportunity to do that. But obviously the court would need to be satisfied on an evidential basis that is in fact the case. But the real key change, I presume, is that the costs that the party is ordered to pay to an applicant don't exceed the monetary amount prescribed in respect to those costs. In other words, the proposal is to introduce a scale fee. So in other words, the costs you recovered will be on the scale fee. And we'll discuss that. And there's an exception for that, obviously. There is a requirement, there is an exception if there's exceptional public importance for awarding costs, and it's in the interests of justice to so award costs beyond the scale. So there is a carve out there, and again, it remains to be seen how that would be applied by the court. You could obviously think of cases, for example, which are test cases, or cases, for example, which may raise some exceptional public point. Does the court then fall within the jurisdiction of those two limbs? Also, there's no requirement, is clearly now required, there's no requirement to give security for costs or an undertaking for damages. That generally is accepted as being contrary to Aarhus anyway. So it's really a codification of what would generally have been accepted as a legal obligation anyway. So the scale fees, a legal assistance scheme, is then provided for. So what the Act provides for is a framework at the moment for the Minister, which is the Minister for the Environment, to make regulations to prescribe monetary amounts, so to prescribe the scale fees, and to introduce an environmental legal cost financial assistance system. So that's the Minister for Environment will have responsibility for that. There is some detail in the legislation about it, but a lot of the detail is unclear because it isn't in the regulation. It will fall to be put into regulations. And it's also clear that it will be a means-tested system, and it appears at the moment it's envisaged that it'll be operated outside of the existing current civil legal aid scheme. So it'll be a bespoke scheme, and it is to be funded out of a pot of money provided for the Oireachtas for that purpose. And there is a consultation process promised, not yet ongoing, I think, but promised in relation to that process. So there are other provisions then that deal with the situation where an applicant is unsuccessful. So whatever about recovering costs, if you're successful, what's the situation if you're unsuccessful? And this the statutory provision makes requirement for that, makes a provision for recovery where you don't succeed. But that procedure requires you to go through an application process, providing financial resources to determine whether you're entitled to proceed that, and then you get your provision for payments under the environmental legal financial system. Again, the outline of that provision is there. Precisely how that's going to operate in detail remains to be seen. There is a mechanism as well under the Act to allow anybody to apply to determine either in advance or in course of the proceedings whether or not these provisions apply. So in other words, you can find out in advance whether or not you have the benefit of this scheme before you take the provisions. And Section 299 is important because it empowers the minister to make further regulations. And Attractor may deal with this in more detail. You'll see that the power conferred on the minister in terms of making regulations is very significant in terms of the substantive content of those regulations. It covers not just scale fees, but all sorts of other matters, and I think Attractor will deal with that. So just a couple of observations here. I mean, this is clearly a very significant departure from the status quo, because although the general rule it remains the same. The big difference is it's now capped at scale fees in relation to it. And obviously that raises questions how this is going to operate in practice and how it will impact on people's ability to get legal representation and how it represents is compatible with our House and associated EU requirements. And the reason for that is that there isn't really a difficulty with people getting legal representation at the moment. It appears to me in these type cases, because the cases are taken on a contingency fee basis for the most part by applicants. The lawyers will look at the case. If they believe that the case has a good prospect of success, they will take the case, possibly on the understanding that if they succeed in the normal way, they will recover costs, and those costs will be taxed to the taxation system in the normal way at market rates, so to speak. If you go to scale fees, the difficulty becomes what is the fee that can be recovered, and if that fee from which is recovered is below significantly below the market rates, then it may not become an attractive proposition for lawyers to represent people. And that then brings in, bear in mind, this really only impacts on applicants. It doesn't impact on respondents. It doesn't impact on developers who would challenge planning applications or development plans. And about a third of the cases in the planning list at the moment, has been that way for a while, are in fact cases taken by developers. I think one interesting thing about such a radical proposal is that its origins are quite opaque. Because it really only arrived in the bill at a very late stage of gestation. It possibly is suggested it's linked to the Kelly Review and the Administration of Justice, which mooted the idea of scale fees and canvassed their introduction of scale fees. But the majority report did not come out in favour of that. And the other thing is, in the Kelly report didn't really identify the planning area as an area of particular issue with fees. Or high fees. In fact, the really high fees are in the area of commercial law, where the fees are multiples of the type of fees that you would be encountering in the planning case. The other question is, as most of you will know, there is an ongoing review of the civil legal aid scheme. And it does seem a little bit odd, if not premature, to introduce a new scheme pending an entirely new bespoke legal aid scheme pending the review of that civil legal aid review. The obvious thing to do would have been to perhaps explore whether the existing civil legal aid review could have been expanded to include these type of cases, either in whole or part, and to have that exploration in the context of what is an ongoing review of that scheme. I mean, the provisions will likely be challenged. I mean, that's highly predictable. And unfortunately, I think it's probably, and a lot of lawyers are predicting that we'll go into a new round of satellite litigation surrounding costs, the whole new rule. And it may be challenging the provisions simpliciter, but it also may be challenging the application of the provisions. It may be how they're operated. It may be the scope of the application, and so on and so forth. And that's predictable. Where that will land, whether they'll be successful or partially successful and entirely successful, I think is difficult to offer a concluded view, simply because we don't really have all of the detail of the scheme. And a lot of this may be very significant as to what level the rates are, the scale fees are pitched at, how those are to be determined, what process are they to be determined by, how the scheme will operate in practice, what will be the criteria, what will be the means testing, how will it operate in practice. All of these things will have, in my view, quite a significant bearing of the extent to which they will stand up to scrutiny or challenge, or indeed how effective they are. Just a very practical operation point to make is they'll have to be very efficiently operated, because most of you know that there are issues around the civil legal aid scheme and delays in accessing advice. But in planning cases, there's an 8-week time limit. So if somebody wants to and is required to avail of the new environmental assistance mechanism, they'll have to be in a position to avail of that promptly, and be in a position to get an answer and to be furnished with advice relatively promptly in relation to it. Because otherwise it seems that the scheme, it's difficult to see how the scheme can be deemed to operate effectively. And again, it just remains to be seen how that will operate. So just on conclusion, there are very significant changes in the 2024 Act. A lot of them are relatively uncontroversial. They would be very technical changes. There would be streamlining changes, which you could say would be welcomed. There are significant changes in the hierarchy, and I think it's indisputable this leads to a much greater range of a degree of centralization within the process, and that in its own right, while you can argue in favor of it, it does raise questions of ensuring there is accountability for a process which is more centralized and concentrates more power on the minister and the central government. And it's in that context, I think, amongst other contexts, and you mentioned and alluded to the pressing needs of climate change and also issues of biodiversity, which need to be assessed in the context of the planning system. Particularly, planning permissions can have great impacts on those issues, and people legitimately want to be able to challenge them on those grounds, as we've seen recently. So in combination with those factors, I think the changes to judicial review proceedings are significant, and particularly the cost provisions are significant, and will probably result in the short to medium term in quite a lot of litigation around that. And the outcome of that litigation will be very significant in terms of individual citizens' ability to access the planning, the courts in challenging planning decisions in an effective and timely manner. So I'm just going to conclude on that note, because I know Attractor needs to take over now.
Thank you, Tom, for providing such a comprehensive explanation of some of the key concerns within the new Act, particularly regarding standing, who can bring cases and in what context, and on costs as well, which is of a major concern to an organisation that does provide free legal advice and would be very concerned about ensuring that low-income communities in particular do have access to justice. I'm delighted now to hand over to Attracta Breen. Attracta is the Manager and Law Officer of Environmental Law Ireland, hosted at An Taisce, where she continues to work on a project concerned with the protection of the environment through the national, EU, and international law, and which she worked on previously as the law officer of the Irish Environmental Network, which is the coalition of national environmental NGOs. Adjunct is also the Irish Council member for the European Environmental Bureau, the largest membership-based environmental NGO in Europe, and is a previous board member and vice president of the European Environmental Bureau, which has 185 members in over 40 countries, representing the voices of over 30 million people. Thank you, Tracta. Looking forward to hearing your thoughts. I think you're just on mute there, Tracta. Thanks also to those of you who are putting questions into the Q&A box. Really interesting, and we look forward to chatting about them after Tracta's presentation.
My apologies there, Clodagh. Can you hear me now?
Yeah, that's perfect. Thanks.
Sorry, it just wouldn't let me navigate to the
No
unmute. My
problem.
apologies for that. I'm conscious we're running a little late on time now, so I'm going to rattle through this. But I would like to just thank CLM for the opportunity, and Tom also for his very helpful and comprehensive overview and introduction. I do have to apologise. I have a dreadful cough, so I hope I won't spend the next 15 minutes spluttering. But like Tom, I would have to say, and I think in general, the concept of a review and reform of the Planning Act was generally welcomed. However, unfortunately, we never actually had a review. There was no published or documented review. There was no rationale for the changes that was proposed, properly aired and shared with the public. And the pre-legislative scrutiny that actually happened on the bill, while extensive and useful in parts, I think it's really important to remember that substantial elements of the bill changed significantly between the PLS version of the draft bill and the final published bill. And I think the other thing that's really important to remember is because we went straight to a draft bill, we didn't have heads of bill with the normal explanatory memorandums that you would have and explanatory notes. And it's in that context that I came to the bill with some apprehension, particularly as I saw the legislative process unfold. Because once we got out of select committee in the Dáil, basically the government used the guillotine extensively. And when the guillotine fell, hundreds, and I do mean hundreds of amendments went through into the bill, changing its text and provisions without them being subject to scrutiny. So we now have the most fundamental and profoundly important piece of legislation for impacting virtually every piece of physical infrastructure and the quality of our daily lives, as you so eloquently outlined at the start of this seminar. And there are real concerns around the quality of the provisions, notwithstanding that there are some improvements, as Tom has said. But where you have rushed legislation, you risk there being errors. And if you have errors in legislation, you have risk errors in flawed decisions. And that leads to delays because invariably then, the challenges emerge. And that's not going to serve anybody's interests, particularly in the context of where we have a housing crisis and where we need to deliver major energy transitions, both in terms of the cost of living crisis and also to decarbonise our energy, and in relation to a whole pile of other infrastructural elements. So one of the core areas for me where you end up with a situation like that, where you're concerned about the quality of decision making that's going to arise, is the focus on access to justice. Because it's in our courts that we actually have our A&E department. So that we should be able to get in and out of there very quickly with a view to being able to resolve the issues. But the concern that's arising, particularly around Part 9 and the changes to the rules and judicial review, is, as Tom has highlighted, that the extent of change and the confusion is actually going to lead to delays, and a layer of what we call satellite litigation being necessary to argue around things like standing and costs, etc., before you can even get into the substantive element. So, what I'm going to do is, I suppose, just highlight also in the context of the centralized control that Tom mentioned also, is that centralized control where you're going to have to make problematic decisions that are going to be politically unpalatable for, both housing, for energy, etc. I personally understand that we potentially need to make some very unpalatable decisions, and a degree of centralized control is necessary. But where you have centralized control, it is absolutely essential that you have oversight and accountability before the courts. Otherwise, you risk abuse, either intentional or unintentional. So that's why, for me, part 9 of the bill, notwithstanding that there are massive other areas where I have concerns and see some positive developments, but for me, this is where the rubber hits the road. So Tom has sort of outlined in quite a bit of detail, some of the provisions that pertain to the changes in judicial review. And what I'm going to try and do is pull back and sort of take a helicopter view, maybe just to sort of say, okay, well, what does this sort of mean in practical terms to us? And then actually then also try and jump in and look at some of the aspects in a little bit more detail, sort of building on the helpful framework that Thomas set out. So just to put the quantity of change in perspective, currently the rules in judicial review in the Planning Act extend to 5 pages. In the 2024 Act, they're 5 times that, 25 pages. And on top of that, we're going to have 2 major sets of regulations around scale fees and this environmental legal costs financial assistance mechanism. So section 50B, which deals with the current cost rules, is 1.25 pages. That jumps to 13.5 pages. So just even quantitatively, we're talking about very significant levels of change. And grey is a lawyer's favourite colour, I always joke. So 1.25 to 13.5, that's potentially a lot of grey, a lot of litigation. So, in looking at chapter 2 of part 9, Tom has sort of talked about chapter 1, and that deals with an awful lot more issues around than standing. It was sort of all sort of the procedural rules really around JR, but I'm going to focus primarily on chapter 2, which is the costs relating to certain proceedings. And the main areas that I want to focus on are what Tom has outlined, that scale fees for applicant lawyers. And I do mean that, applicant lawyers. It is just the fees for one side. So for the public, for NGOs, and indeed developers taking challenges against decisions, but not for the state respondents or the notice parties. And then there's an environmental legal cost financial assistance mechanism, which may sound good, but spoiler alert, I would have serious concerns in relation to that. Both of the regulations, as Thomas highlighted, are brought forward by the DEC Minister, but ultimately they are consented to by the Minister with responsibility for the money. Deeper basically, makes the final call. And I think that we should be mindful basically of the mentality and the priorities that will thus inform. And I'll talk a little bit more about that. It's interesting to note that in relation to the scale fees provisions, it's a shall prescribe, that the Minister shall prescribe regulations. But in relation to section 299 and the environmental legal costs mechanism, it's a may make regulations. So that might imply to some that there's a degree of discretion where you could have one without the other. But if you actually look at chapter 2 in detail and carefully, it is a bird with 2 wings. You need both. You can't have one without the other. So that's sort of an important thing to bear in mind. This sort of is my pullback, satellite image of what we're talking about here. Basically, it's a profound change in relation to the way the current rules operate, but because win or lose, the state will pay. Currently, if you win, the state pays, but if you lose, you have to carry your own costs effectively, and that's subject to the arrangement that you may have with your lawyers. And I think a lot of people will be familiar with the concept of a no fault, no fee mechanism, which is facilitated effectively, finally, is the start of the flow of environmental litigation in accordance with our EU and our Aarhus obligations. So basically, whether it is somebody basically putting their hand into the pot to draw on their win, or with their hand out when they have actually lost, and the state pays. So it's interesting to see how the state actually decides it's going to manage its exposure. And I think that's the way we need to look at it. It's going to manage the level of win by being able to play with the scale of fees that go out to the applicants, the people who are challenging. And on the losing side, then it controls how much you will actually get. So for me, this is a really problematic paradigm shift because the state has ultimate control over who can afford to go to court and how effectively they can mount their challenge. And it can control the mechanism by which they feel certain or uncertain around that and the appetites that they have as a consequently. The concept of non-prohibitively expensive, which many of us will be familiar with, as an EU law requirement, I would say not just associated with sort of the underpinning Aarhus requirements and the Aarhus Convention itself, but also in relation to the principle of excessive difficulty because of the scale of litigation costs in Ireland and principles for an effective judicial remedy under the Charter. It emerges as a poor relation here. It's something that has to have regard to, which it has a very low threshold. Basically, have a think about it and you're grand. You can tick the box, but you're not bound by it. So that's a very, very problematic, and we see that emerging both in relation to the scale fees and in relation to the legal costs. The other thing to bear in mind is the current rules in Section 50B operate across all sectors. And while the 2024 Act sets out these rules just for planning on matters under the 2024 Act, these rules will be expanded. It's in the legislative programme that there's going to be an Irish legal cost bills to expand these across multiple sectors. So the state basically in Chapter 9 has created a whole pile of little cogs, wheels and levers that it can use to good or bad effect to make this work generously or ungenerously. And I think that's why, from the point of view of my initial reaction to this, I differed, I suppose, from yourselves and CLM and EJNI, because I don't think it's appropriate that the state can control who can hold it to account and how well they can do so. It doesn't matter whether it's compliant with Aarhus, so to speak. I think that's fundamentally a principle and rule of law issue that I personally am very concerned about. The spoiler warning there is the cost changes. As I've said, state controls, there's a lot of uncertainty. There's huge unestimated state exposure in terms of what's going to emerge consequent on all the satellite litigation, the complexity of this being across multiple sectors, the potential for this new system to be exploited and tapped into. And the current costs incurred basically are no basis for future estimates. And if the state starts to hurt, invariably then there would be pressure put on downward adjustment in relation to the generosity of the scale fees or the environmental legal costs mechanism. There's also serious concerns in relation to the transitionary provisions and major gaps and lacuna in respect of how we flow from one system to the other, because right now when Chapter 3 is commenced, it allows for the current rules to continue to operate until Chapter 1 is commenced. But of course, the cost rules are in Chapter 2, so that leaves us with a major lacuna in relation to cost provisions. So to quote somebody, it's very, very bad, very, very bad. I'm really conscious that we're really running out of time, so I'm not really going to be able to go into things in a whole lot of detail. But what I would say is that the basic concepts are somewhat similar in the sense of that each side still bears its own costs. As Thomas highlighted, the conditions are expanded where the cost shield can be punctured. You can gain some of your you can gain some of your costs if you're successful. But the really key thing is now that there is a ceiling on the cost award and a very strong limitation on the judicial discretion associated with piercing or going beyond that. So you are limited, effectively, the court is limited unless it can exceed a very specific threshold in order to award you something beyond the scale fees that the minister will prescribe in relation to the costs that you're entitled to. As Tom mentioned, the security on costs for undertakings has been removed, and that's possibly the only positive that I see in relation to Part 9. I would also highlight that it's not just a case of that you'll get your costs, whether you win or whether you lose. It's very carefully worded in relation to that the losing component, where if you get a contribution from the Environmental Legal Costs Financial Assistance Mechanism, will be a contribution. The extent or level of that contribution in terms of the scale of fees that you've incurred remains to be seen. As Thomas highlighted, the minister with responsibility for the environment brings forward the regulations, but ultimately it's deeper that actually consults to them and or consents to them. And it's very important to realise that the costs are only in respect of the legal costs. They're not associated with your expert costs and your other disbursements associated with. So that's a really serious narrowing in relation to the extent of reward that you actually get. I've mentioned the shall have regard to, and I think it's really important to emphasise that the NPE requirement, the not prohibitively expensive, is but one of the considerations that is to guide the minister when they're actually developing the regulations. And you can see the other provisions there, including the cost to the Exchequer of matters provided for by such regulations. And I think everybody will know that that's quite a chilling implication. So in summary, it applies only to applicant lawyers. How can that be fair or equitable? Because you have a fundamental inequity in terms of equality of arms, where you have one side being potentially paid substantially more than the other. Only covers legal costs. NPE is only have regard to. The court override is very limited. And ultimately, an applicant and a lawyer can engage for a greater fee. So lawyers may still hold that they actually need more. So you could win your case and still end up actually having a substantial loss and cost exposure to you. As Thomas mentioned, there was a civil legal aid review, and I'd just like to highlight, the review of the administration of civil justice. That really kept planning JR out of scope. It's very, very clear. And notwithstanding that the minority report indicated an appetite to deal with scale fees, planning JR was out of scope. So the minister basically commissioned an Indicon report in the Minister of Justice, that is, with the view to deciding what was an appropriate approach to dealing with the cost of litigation and the issue of lawyers' fees. And that report only came to be published 4 months after the Cabinet had made a decision to advance scale fees in the Planning Act, and 2 months before after the bill was published with the scale fees applications. And the Indicon report, when it came out then in February, actually indicated that there was substantial evidence gaps in order to making a sound policy-based decision on scale fees for lawyers. And as Thomas highlighted, if you were starting to dealing with litigation costs in Ireland, planning wouldn't be the first area that you would start with. So that it begs a lot of questions, not to mention the ongoing civil legal aid review, which is very relevant in the context of the Environmental Legal Costs Financial Assistance Mechanism. And I'm really going to have to just glaze through this, so you'll forgive me. But this provides for a scheme which an applicant who is unsuccessful, either in part or in whole, can make an application even before the start of proceedings to understand whether they are going to be entitled to it. And there are two limbs to it. There's a means limbs in terms of your financial means, but there's also an eligibility type consideration. And you have to meet both. And the provisions on these are set out in regulations, so we have yet to see what these are. But we can see enough from the provisions and the regulations that there is a lot to be concerned about. But even before, just taking a step back and thinking, gosh, legal aid, I'm going to get paid, even if I lose, isn't that great? Just think about the two spectres of civil legal aid and criminal legal aid that we have right now, and the inadequacies in relation to how those schemes operate. If we can't run legal aid for children and families, if we can't run legal aid for people who have a right to be considered innocent until proven guilty, what hope for the environment? The additional spectres that come associated with this new scheme are that even if you are entitled to it, up to 8 weeks after the proceedings finish, you can be pursued and your entitlement punctured and challenged. And they're quite extraordinary wording around how such orders can be made by a court, and how somebody can go and make an application to the court for that. If any part of the proceedings was considered to be frivolous or vexatious, which means that it didn't have a chance of succeeding, but it's any part of the proceedings. Or, if you were found in contempt in respect of any part of the proceedings. So you could really forfeit your entitlement. So there's some really powerful mechanisms to puncture all of this. As I've mentioned, the concept is both of means and eligibility. And you can get an advance determination, but basically that can be decided up to 28 days, which is 4 weeks into your 8 weeks JR period, or which other period has to be provided for. And when you actually look at what you need potentially to provide in order to be able to determine whether you have the correct means, it's very unclear the standard of detail that you're going to have to provide in relation to your means. You may actually have to certify and have that attested. If you make false or misleading statements, you can forfeit your application. If you the eligibility requirements go to things like as to extraordinary decisions, which and I'm just going to skip a few slides to bring us to that, is whether you're going to have sufficient interest, whether you're going to have likely win your case. How are you even going to engage your lawyers at this stage? And yet you have to come forward potentially with these types of an articulation of a case without even knowing whether you can engage lawyers. It begs a huge amount of questions as to what we will actually ultimately see in the regulations. But this concept of both means and eligibility provide a mechanism which, for not just an initial setting out, but for this to be endlessly tweaked and then to be endlessly challenged in relation to its fairness or equity. And I think therein is a recipe for disaster and a recipe for delay. So ultimately what we're seeing here is that you have an inequity and an inequality of arms where the state can basically say to you, okay, we'll play a game of football, but I'm going to determine who can play for you, how long they can stay on the pitch, and by the way, I'm going to be playing for the team from the Premier League. Oh, and I might change the rules midstream. So if you like that, you like part 9. I don't. And I think there are really, really serious issues here. And I don't think we should just sit back and assume that, that this is just going to flow and just because the bill has been enacted. This needs to be fought. This needs to be fought. Tom referred to a consultation. That's a may. There's no guarantee for consultation. But this is something where we have to push back on politically and mobilise around. The timeframes in which these are going to come forward are very unclear, and I've run out of time, so I'm going to have to stop. But we can talk, and I would urge people to keep engaged with us, and I look forward to working with everybody in relation to how we address the challenge of the rollout of these regulations. I'm not going to be able to talk about that. Sorry.
Thank you so much, Attracta, for such a fabulous presentation. I think we could listen to you both all day, and I'm really sorry actually that we didn't schedule this event slightly longer to allow for that. I'm conscious that both Attracta and Tom have other engagements, so we are going to have to wrap up, but I have taken note of the questions asked and we can get back to you following the webinar. I think what's really clear from today is the public needs to have a voice in environmental decision making. Mobilisation within communities on environmental matters is increasing, and that should be encouraged, particularly in the context of the successive failures of government on environmental and climate protection. I'm extremely grateful to Tom and Attracta for their very comprehensive and authoritative insights into the risks contained in the new Planning and Development Act. And I think we all benefit to listen to the call to action provided here today. This webinar is recorded and it will be available online in a couple of days. Thank you so much to everyone. And I really apologize again for not getting to the questions in this session. Thank you so much.